We thank you for all the mercies that you continue to bestow on us. Continue to guide us and guide us as we pursue these discussions so that we can all come to consensus on the matter at hand. These are the mercies we ask in the dear name's sake. Amen.
Amen. Let me welcome everyone to this resumed meeting. It's been a while. I think our last meeting was on the 30th, Madam Clerk? 30th of March. Since then, we had a meeting cancelled to enable the committee clerk more time to prepare the minutes of the meetings. Having discussed the resource constraints with the clerk, it was clear to me that even with the best of intention and the best of effort, given the other work assigned to this clerk and other clerks, more time was required to complete the work between meetings. I've been reflecting on that against the backdrop of concerns raised about the pace at which the Parliament does its work and the pace at which we turn over. When we are considering the issue of timeliness, it's always good to consider whether we have the resources to do the work. The capacity of the Parliament to deliver on its legislative work is one of major concern to me, and I have indicated elsewhere that we must move quickly to capacitate the Parliament to ensure that it can function efficiently. I am now looking forward to the new Parliament infrastructure to be built, because it is very clear that what we have currently will not enable us to operate more efficiently. We can't have two meetings in the same place. We can't have meetings when it's the same set of support staff assigned to each committee. We are at an important juncture in the nation as we look on reforming the Constitution. We look on ensuring that the machinery of government through the various branches can better serve the people. We will have to look at the resources that are made available to do the work of the people. The members of the committee have not all been in attendance for critical meetings, and in particular for full duration when the issue of the constitutionality of the pre-charge bail regime was considered. When the bill was first tabled, there was a massive hue and cry about the constitutionality of the proposed regime. We took submissions from various groups and individuals, and I want to express my thanks to all who have taken the time to make submissions on the bail bill. As I was going through the minutes, I see that practically everyone has contributed something that will make the bill a better bill, even though we have not accepted all of the submissions made. And I have taken the time to make this point because, like so many others, I share the view that the laws that we are proposing can always benefit from the input of the people. Having said that, I will also say that it will be important for you to take time to do the research, especially if you're coming to the Parliament as a learned person or representative of a learned group. The expectations are high that the analysis provided will be accurate and helpful and supported by authority, especially if you represent the legal profession or you are a trained lawyer. It is never enough to merely allege unconstitutionality without at the same time demonstrating how you have arrived at the conclusion. Thankfully, between the time when we commenced our deliberations on the bill and now, we have had the benefit of seminal decisions from the Privy Council clarifying the approach to determining constitutionality of provisions, the latest being the Attorney General and the Jamaica Bar Association matter, popularly called the poker case, dealing with the AML CFT provisions. And by AML, I mean anti-money laundering, and by CFT, I mean countering the financing of terrorism. We are moving in the right direction, slower than I had desired, but I think all in all, the time that has passed between commencement of the work by this Joint Select Committee and now, that time has allowed for critical thinking and reflection around the provisions and the work that we're doing in rewriting the bail law. I want to say a special thanks to the committee clerk. I find generally the quality of the minutes to be high, and all minutes will have errors here and there, but generally I find that the records of the meeting are accurate in substance. It's not easy to take notes. It's not easy to review the recordings done by Zoom. In fact, to go through takes as much time as the entire meeting that was held. And that is being done in addition to other things. So I just want to put it on record, my appreciation to the clerk and the support staff, for the work done behind the scenes. Those really encapsulate my opening remarks. I'm moving to agenda item 4, apologies for absence. I have apology from Senator Scott Motley and Senator Bunting and also Minister Chuck. If other members have received apologies to be conveyed, I will take them now. All right, it appears not. We will move to confirmation of the minutes of meetings held on March 23, 28, and 30. I know the minutes were circulated with not much time to allow for the reading through. The good thing is that they were circulated before today's meeting. I know that all committee members have other things that they are dealing with. And so I imagine that not everyone may have had the opportunity to read through the minutes. I'm therefore suggesting for consideration that we spend some time to read through the minutes, because the record will serve as an important memory aid and also provide information for those members who did not stay for the entire duration of the meetings. So if everyone is agreed that we go through the minutes, I would start with the minutes of March 23. Now, these minutes are particularly important because they record the discussion of the opinion from the Attorney General's chambers on the constitutionality of the pre-charge regime. I will just pause to take comments from any member.
I'm not hearing. I'm not hearing.
The mic may not be functioning, even though the light is on. For those who are online, just bear with us for a moment while we take corrective measure. Please try again, Member Williams.
Hearing you now.
Member Williams, I suggest that you change your seat.
Madam Chair, are we still pausing to allow us time to read the minutes?
Member Rodriguez? Who is that?
Yes, it's Natalie Campbell Rodriguez here.
Yes.
I was just double checking whether or not we were still paused for us to just have a moment to read through the minutes.
Well, yes, but perhaps we can go through. I was throwing it out to hear from members about the preferred approach, but we must go through the minutes. The minutes of March 23, 2023 are particularly important because the opinion of the chambers on the constitutionality of the pre-charge regime is set out in this record. So we can either read it aloud or I can pause and allow for a page by page for members. I am open to your suggestion. While you're thinking about it, I was wondering, and I'm seeking clarification from the clerk, when we do the correction of the minutes, do you go back to correct the minutes as indicated when they are confirmed, so that ultimately when we pick them up, they are actually showing the corrections made after they are reviewed? Yes? Ah, thank you. Right. So, very well. All right. Let us begin at page 1. Page 1, setting out attendance. Please check if all names are accurately written. Members present, in person and virtually. Members absent, including those who sent apologies. Those who are also present. If no correction, then we go to 2. No correction, 3. We go over to page 2. This is where Member Williams was asking that the spelling of his Christian name be corrected from Donavan to Donovan. So it's Donovan. Okay. Paragraph 5, welcome and opening remarks. Paragraph 6. Paragraph 7. We move over to page 3. First paragraph on page 3, second paragraph, third paragraph, fourth, fifth, and sixth. If no correction, then we can move over to page 4. Page 4 has the constitutional provision at the top. Second paragraph, third paragraph. There's no correction. We go over to page 5. On the paragraph on page 5, I see article is written as 5-1-C. I know I can understand the logic of it when we say Article 5-1-C, but I think it should be in parenthesis. 5, open parenthesis for 1, close parenthesis, and then open parenthesis for C and close parenthesis. And for all of the others that are written that way, that would be the correction. 5-1-C. I am holding it up so if it can be viewed on the screen. Maybe not, but I've shown to the clerk. Mr. Foreman, you are with us. May you just check for me the line which, in the paragraph commencing, Mr. Foreman advised the committee. In that paragraph, we're skipping down to about the first, second, third sentence. There is no reason to believe that the police investigation in this case was... my error. Sorry. My inquiry is no longer necessary. All right. The correction that I see on the last paragraph, starting Mr. Foreman said that the principles from Brogan had been affirmed and it would be were instead of was. The principles were applied.
Madam Chair, a clarification needed. May I go ahead?
Yes.
I note that in the minutes from beginning on page 5, there's a reference to ECTHR.
Yes.
What is the T for? Because it occurs over and over.
It's a European Convention on Human Rights, and then the ECTHR is the European Court on Human Rights. So where you see the CECT, common T, HR, that is a reference to the European Court on Human Rights. And then the ECHR is the European Convention. It's actually set out just a little above where you see Mr. Foreman commented that the European Court on Human Rights, and then in parentheses you see the abbreviation. There on page 5 in that first paragraph. And
thank you, Madam Chair.
Yes. All right, so that's one, in addition to just correcting how the articles are written, the correction there is changing was to were in the first sentence of the last paragraph. We move over to page 6. The similar corrections to how the article 9.1 is written. Instead of the dash, it would be open parenthesis for and before the 1 and close parenthesis. And the same thing for Article 9.3, Article 5.3. Right, if there is no other correction on page 6, we move over to page 7. This is at paragraph 8, new business. So it begins with review of the matrix of submission, first paragraph. There is no correction. We can go to the paragraph headed Cornwall Bar Association. And under that, the third paragraph, where it said, third sentence of the third paragraph under the heading Cornwall Bar Association, she said that the Bail Act had placed a burden on the defendant to prove that bail should be granted, but that was not the case with the bill. I think that reference was to the 2010 amendment to the Bail Act, which was struck down. The Bail Act does not have a burden on the defendant to know that bail should be granted, but previously there was an attempt so that a previous amendment to the Bail Act, I know there is a way you would have formulated the minutes, but substantially this is not correct. So if you are sure that was said, then I would have to correct it as a matter arising. All right. All right. Yes. So it really is to read that a previous attempt to amend the Bail Act had placed a burden on the defendant. That is really what it was referring to. All right. Any other correction? If none, we can move over to page 8. Paragraph commencing Senator Scott Motley. If no correction, we can go to the paragraphs under the heading of Jamaican Bar Association. Paragraph starting commencing concerning clause 7.3d. Then paragraph commencing with respect to clause 7.3e. Next paragraph commencing the Jamaican Bar Association noted that clause 7.4. Next paragraph commencing Senator Campbell Rodriguez. If there is no correction, we can move to page 9. I was just wondering, under the paragraph headed clause 3, applications, was the word detainment or detention? Ms. Wilkins? Is Ms. Wilkins online from, I'm not seeing her among the, but I see the LRD.
Yes.
Was it detainment or detention?
Detention.
Yes. That's what I thought. That's what I thought.
Yes.
Yes. So we change detainment to detention.
Yes.
All right. All right, if there is no other correction on page 9, we go to page 10. Just aside, on the paragraph commencing regarding clause 5.8, I note it is now quite fashionable to say treat with. And a debate is raging as to whether that is grammatically correct. You deal with, but you treat a journalist who regularly tunes in to watch the proceedings of Parliament, whether of the whole House or committees of the House, wrote me to say, beg you please, tell your colleagues that treat with is not grammatically correct. I noted that we have almost normalized that way of speaking. I just say it for what it's worth, for members to consider, members and supporting staff. Right, if there is no other correction, we can move to page 11.
Yeah, Madam Chair, before you move from page 10.
Yes.
The paragraph headed Jamaica Constabulary Force, JFC.
Yes.
At the end of that first paragraph, it says the committee requested that Ms. Grant amend the provision to reflect the recommendation made by the JCF.
Yes.
But my recollection is that I had actually proposed an amendment that had been accepted. So I think the minutes should reflect what had been accepted, which is not necessarily identical to what was recommended by JCF.
I see. And you would ask that the correction to what is there be read as instead of so the committee requested that Ms. Grant amend the provision to reflect. So it's a concern, the amendment to reflect the recommendation?
Yes, it wouldn't reflect identically the recommendation. I believe the record should reflect that the amendment that I proposed was what was accepted.
So the request of the committee, which resulted in your proposing something, was a request to amend the provision to address the recommendation made by the JCF?
So, Madam Chair, for example, if you look on page 9 under the paragraph headed Jamaicans for Justice,
yes,
the actual amendment that was accepted is quoted at the end of that paragraph.
Yes.
So I'm suggesting that a similar quote be made for the amendment that was accepted.
All right.
Reference there.
You would have to remind us what that was, Madam CPC.
Right. So I had proposed that at the end of paragraph 85B, the following words be inserted. And the court may give such that. Sorry?
Just trying to make sense. So the committee had requested that the provision be amended, and then you proposed something which was accepted.
Yes.
All right. So let's get what had been proposed and what was accepted, and then we will just correct the action taken by the committee.
Right. So what I had proposed was inserting the words, and the court may give such directions as it considers appropriate.
Please go slowly. Please go slowly.
And the court may give such directions.
Pause.
As it considers appropriate to enable the police to monitor compliance with the requirement.
To monitor?
Compliance with the requirement.
I think what happened, Madam Clerk, because that actually is reflected later on in the minutes. So I'm looking back where I had read it. All right, I know I saw that the committee had, after discussing the issue, the committee had decided that the court would the provision JCF, just give me a moment. I'm just looking back on something that is recorded there to that effect, that after the matter was discussed, the decision was taken to amend the provision so that at the time when the court is making the order, the court would also direct how the police could monitor. I'll come back to it. All right. It's right up the top, just ahead of that. Mr. Grant said that the clause could be amended to indicate that the court would be empowered to authorize the officer to make the check. So the sentence just above that. And then the committee requested that you amend the provision to reflect the recommendation. So it would be...
Well, that also is a little different from what I had actually drafted and what was accepted, because the provision is not for the court to empower the author
right.
or to authorize the officer to make the check, but to give directions to enable the officer to monitor the compliance with
right.
the requirement.
So that was also discussed, because if you see the sentence which said the chairman indicated that the police did not need any special provision to monitor people on bail. However, she recalled that during their oral submissions, the police had indicated that people had made complaints of being harassed by them. So, all right. So the committee requested that Ms. Grant amend the provision to reflect what was discussed, and the committee accepted. I'm trying to. Is it just merely that Ms. Grant, as is written previously, Ms. Grant suggested that the provision could be amended to read as follows, and then the committee accepted the suggestion?
I could list and check in the fridge before you put things on the list.
Senator Campbell Rodriguez, please mute your mic. Right. All right, so let's just correct it that just propose the correction again. We know what is to be inserted, but just propose the correction to the action taken by the committee, Madam CPC.
Instead of what is in bold, it could read, Ms. Grant suggested that the provision could be amended to read as follows.
Okay.
And, well, you have what I read. I think that's it.
Right. Very well. So we would. So it would be that the committee requested that Ms. Grant amend the provision, and Ms. Grant suggested that the provision could be amended to read as follows. Okay. Insert the words, open quotation, and the court may give such directions as it considers appropriate to enable the police to monitor compliance with bail requirements. Close quotation, full stop and close quotation.
I'm sure.
Yes.
If I may, and that it is more to Ms. Grant.
Yes.
And you give me what were you contemplating in respect to that amendment? And the court may give such directions. Is it that you're saying that the court would say to the officer or that the police should check only between 7 o'clock and 9 o'clock, or if they are on a curfew that takes them from, say, 6 o'clock in the evening until 6 a.m. the next morning? What direction could the court give for them to?
Member Sinclair, can you just note it for a matter arising?
Okay,
so we could
well.
just get through the amendment. Right.
Okay, very well.
Right. Thank you. So I'll just put a note that we'll come back to it. All right. We were on page, with that correction, we moved over to page 11. Is that a double that there in the last paragraph, fourth line from the bottom? JFJ noted that among the issues should be noted that among the issues affecting the Chamber's case. So we delete one of the that's. You seen it? All right. If there is no other correction on page 11, we go over to page 12. All right, a paragraph on the Norman Manley Law School. All right, if there is no correction on 12, we go over to 13. All right. The corrections are noted. Will someone move for the confirmation of the minutes?
So move, Madam Chair.
Campbell Rodriguez? Yes. Seconded by Member Williams. I think you were the one that stayed to the very end. Were you there or late? Or absent? Can't remember. Seconded by? No one to second the minutes? Would that fall to the
I'm trying to second it. I'm sorry, Dr. Charles. I'm trying to second it, but
right.
people keep calling me on the phone. So
yes,
sorry.
Yes, Dr. Charles. I think you were one of the others who stayed to the very end.
Yes. So sorry that every time they call, it takes me off my Zoom. All right. Thank you.
Thank you. All right. Matters arising from this minutes. Member Sinclair, you were posing a question to the CPC.
Yes, thank you, Madam Chair. But I was inquiring to that amendment that speaks on the court may give such directions as to enable the police to monitor compliance with the requirement. That is the curfew requirement. I'm just trying to contemplate or consider what was in the mind of Ms. Grant in adding that, as against the police doing for themselves and taking all such necessary steps that they believe they can take in ensuring compliance. Why would we want to place that on the court as to how they should go about making compliance? The court should say, is it that she's saying that the court should say, all right, make a telephone call to the premises, visit the premises. And if they're visiting the premises, you can only visit the premises between the hours of so and so and so and so. Because normally what happens is that the court will place a curfew on an individual between certain hours, say 6 o'clock. Depending on the court is very liberal, I believe. If the person explains that they have work that takes them up to, say, 8 o'clock, the court will say, all right, so you get home in an hour's time, your curfew starts at 9 o'clock until 6 o'clock the following morning. Now, what I see in practice is that the police will visit the home to ensure that the person is there, but they don't know what time between that 9 o'clock hour and 6 o'clock hour that the police will check on them to ensure that they are actually at the premises. But I was just trying to, why add that as almost a proviso to what is already contained in the draft? Is it that we are putting up a burden on the court to specify how it should be done, when it should be done, within the particular hours of the curfew?
Before the CPC comes in, it may be helpful, Member Charles, to just remind yourself. I think you were absent at that meeting.
I was absent.
Right.
Yes.
So if you look at what we were discussing, it was a request that a provision be included that would expressly authorize the police to visit individuals who were subject to curfew orders as a condition of bail. And we looked back on what the police had presented on. I reminded that police really don't need any special provision to enforce the law. And in this case, monitor, the particular law now would be monitoring a condition of bail imposed by the court. But that they spoke about challenges that they faced And in the deliberations, some members were, having recalled the concern raised by the JCF, were in support of the recommendation made. And then we looked at options if there was a genuine problem, options that could address the concern. Instead of putting a specific provision. So that was the suggestion.
Yes, I think I recall the concern that the police raised, where they said that persons were complaining about
harassment.
And the attorneys too, that they are saying, "But why are you coming to my premises?" Right? Was that the concern? Because what I see the concern that I generally hear is from persons saying that it is the manner in which the police comes to the premises. They will come and they will turn on the siren in order to try and get their attention whilst they sit in the vehicle for the person to come out and create a disturbance. I don't think that person's actually, I've never heard a complaint of a person saying, "You're coming to my home to check." It is the manner in which they come there to do the check that it is a bit,
right.
Most times on the low side.
All of those were discussed, Member Sinclair, again, in the absence of hearing the deliberations. The gist of it is recorded, but the matter was discussed at length. So it's not that the court must give a direction, but having the committee accepted that there appeared to be a genuine concern and was looking at a compromise way to solve the problem without creating a bigger problem. And I think it was against that backdrop that the CP suggested that the words could be added there in the same provision where it would impose the condition that it may give such directions. Any direction to be given would naturally have regard to what is presented to the court. Remember, another bit of the concern was the different ways in which different judges approach the matter. So including something to nudge the court to say you are at liberty to give directions based on what is submitted to you, you can do so as is appropriate to enable monitoring compliance with bail requirement. It's in that spirit. All right?
Thank you.
Yes. Okay. The other matter that I thought I may just... there are two matters that arise. The LRD was to come back with assisting the committee on penalty for tampering with the electronic device, monitoring device. And the committee was to further review the suggestion, the concern that was raised about the inclusion of the offense of failing to disclose identity in the schedule. Since the penalty prescribed for the offense under the Law Reform Zones of Special Operations, Special Security and Community Development Measures Act clearly indicated that the offense would be a minor offense. We were to rethink why it was included or whether the treatment of it in the ZOSO law should be looked at. Team LRD? Yes. So that was followed up on. Remember, we have a series of minutes, so we can just say on that matter it was followed up on in a subsequent meeting. All right? I want to ask members of the parliamentary opposition in particular, where they now stand, having regard to the presentation made by the chambers on the constitutionality of the pre-charge regime. Bearing in mind it was a specific request coming out of the opposition caucus on the committee for further assistance from the chambers in helping them to address their concerns and the concerns raised by others about the constitutionality of the provision. The mechanism, rather.
If I could just say, Chairman,
yes,
that I've only been able, since the draft report has come, been able to discuss it or start a discussion with my colleague, Senator Scott Motley. In fact, it was just before the meeting started when she did indicate she was going to be unable to make it, that we agreed that we would ensure that the discussion from the AG's chambers, that they be highlighted to the other colleagues from the opposition, and that we would mull on it. So having discussed it with her, we did say that we're going to go through it in some detail. And I think we'll be in a position then, having regard to the AG's opinion, to be a lot more definitive in our own submission. So we're asking for a little bit more time.
Okay, all right. All right. May I suggest also that you may find it useful to look at the parts of the judgment in the Jambar GLC case around the Constitution, looking at how the test to be applied in derogation and how what is demonstrably justified in a free and democratic society is to be interpreted. I think the passage of time.
Yeah, so we did agree that the submissions made from the AG chambers were very useful.
Right. All right. So you're asking for a little more time to complete the opposition's deliberation. I can understand that. All right. And remember that you also have the full opinion in writing from the chambers.
Yes. Yes.
All right. So we have confirmed minutes of the 23rd. We will move to minutes of the 28th. If committee members do not mind, maybe we could go a little slower, though it's shorter minutes, to just ensure that they are read through. I had pre-read the minutes of March 23. All right, so we're moving now to the minutes of March 28. Page 1, paragraph 1. It may be helpful to indicate when a member leaves the meeting. In the cabinet, that is regularly done. If you step out at a particular time and step back in, it shows it. Sometimes it's helpful if members are wondering whether they were present at a particular time. I'm thinking out loud. I know you members may be hearing me. We can talk about that. All right, page 1, paragraph 1, paragraphs 1, 2, 3, and 4. Member Williams, your name is spelt correctly here, so that's clearly a small typo on the previous minutes. All right, we move to page 2. On page 2, in the penultimate paragraph, however, the response provided instead of provide. The response provided did not shed any light. Over to page 3, if no other correction. Thank you. All right, moving down to the paragraph on the Norman Manley Law School. I think that Crown should be a capital C. Submitted that the Crown did not need 72 hours. Which means a prosecution, and very soon we won't be using the term Crown in our laws. Paragraph, clause 13. Parish court judge, I think, should be capitalized. Or, consider that, it may or may not be. Yes. If no other correction, apart from the slight typo on 3, we go over to page 4. Moving to the paragraph submission made by Mr. Jordan Jarrett. If no correction, we move to page 5. So the rights provision, it would be one word with a dash between. That's the, under the paragraph, clause 4, clause 14. She pointed out that section 50 of the Constitution had been repealed and added that the rights provision, it should be a dash between it. All right, we move over, apart from the minor addressed amendment, we go to page 6. So it would run consecutively to and not consecutively with. It would be concurrently with, but consecutively to the offense for which he or she All right. If there is no correction to page 6, we go to page 7. Double dot on third paragraph, he stated that there might be conditions that could be considered, that could be considered reasonable. Just delete one of the that. Right. If there are no amendments to page 7, we go to page 8. Clause 18(1) B to D, I think you need to open the close the parenthesis after B and open a new one after D. Yes. If there is no other correction to page 8, we go to page 9. should be 4 in other 4. So, Chairman, at the penultimate paragraph, that the matter should be raised in other forums, that should be other fora. All right. If there is no other correction, we skip over to page 10. Will someone move for the confirmation of the minutes of March 28?
So moved.
Thank you, Member Charles. Seconded by? Seconded by?
I was not present, but the seconder does not have to have been
Right.
present, Madam Chair.
No.
So I will second.
Thank you, Member Sinclair. Any matter arising? I just use the opportunity to say that in respect of the recommendation by the Jamaican Bar Association about passing a special bill under utilizing Section 50. Right. I just say for information that Section 50 of the Constitution had provided for somewhat a parliamentary supremacy provision that where 2/3 of the members of the House pass a bill, then it wouldn't be considered to be inconsistent with the Constitution. But we have taken out that provision from the Constitution. And Section 2, which is the constitutional supremacy clause of the Constitution, the one that speaks to the effect of the Constitution being the supreme law and how any inconsistency with the Constitution is to be treated. We have a tidying up of that provision to be done. But as we are in the realm of constitutional reform, I want to invite members of the legal profession in particular to just spend a little time looking on the Constitution. It may be helpful, to just refresh your memories. A lot of people talk about the Constitution, but we're realizing that many really do not know what is contained in the Constitution. Many are familiar with some of the provisions, but really do not understand the constitutional scheme that we have in Jamaica. All right, having confirmed the minutes of March 28, we move to the minutes of March 30. I didn't get an opportunity to read through this one, not to wear anyone down. If you don't mind, we could just read it very quickly aloud. And since I'm making the suggestion, I could start. Paragraph 1, attendance. Those present, those absent, those also present. Call to order, prayer. Stage 2. Apologies were tendered on behalf of Senator Charles Sinclair, Senator Scott Motley, Member Horace Chang, Member Fitz Jackson, and Member Philip Paulwell. The Chairman, 5, welcome and opening remarks. The Chairman welcomed everyone and said it was unfortunate that the meeting was commencing more than an hour and a half after the scheduled time due to the lack of quorum. She indicated that it was important for members to be present because the committee would be reviewing Clause 5, grant of bail prior to charge. She said that the clause was considered by the opposition and the public to be the most controversial one in the bill, and the committee had agreed that it would review the other clauses before considering it. Chairman indicated that the opposition had requested guidance from the Attorney General's chambers on the constitutional issues raised by presenters. She advised that at the previous meeting, the committee had benefited from the opinion prepared by Mr. Jeffrey Foreman on behalf of the Attorney General's chambers. She said that she did not know whether the concerns regarding the constitutionality of the provisions still remained, but she suspected that there might be other issues based on what was previously expressed. She reiterated that it was unfortunate that the members of the opposition were absent and added that Senator Scott Motley, Member Jackson, and Member Paulwell had tendered apologies. She indicated that the government had taken the decision to update the law and address some of the challenges while ensuring that certain guaranteed rights would be respected. The chairman stated that the minutes of the meeting held on March 23 and 28, 2023 were not yet available because the committee clerk, who was required to prepare the documents, was also assigned to other committees, and there were several meetings held. This meant that there was little time to draft the documents. She said that there were 2 outstanding matters for the committee to consider, namely Clause 5 and the schedules. The chairman asked Ms. Wilkins to read the submissions which were made in relation to Clause 5. She commented that in an effort to ensure that no one languished in custody unless sufficient cause was shown, the government had taken the decision to provide a new regime for dealing with people who were arrested on reasonable suspicion of having committed an offense, but against whom charges were not immediately brought. Ms. Wilkins asked the chairman how she should proceed. Chairman responded that the committee would consider the comments made by the various presenters, which were outlined in the matrix of submissions. Member Williams requested a copy of the opinion, which was prepared by the Attorney General's chambers. He added that he had indicated that he would not have been able to attend the previous meeting. The chairman advised that the document was circulated electronically. Paragraph 6, new business. Clause 5, grant of bail prior to charge. Jamaican Bar Association. Ms. Wilkins read the submission made by the Jamaican Bar Association. She noted that the association had submitted that pre-charge bail should be restricted to cases where there were reasonable grounds that a suspect had committed an offense under Part 1 and Part 2 of the second schedule of the bill, and there were reasonable grounds for believing that the suspect would abscond, commit an offense while on bail, or interfere with witnesses and ongoing investigations. It was noted that while the association had supported the introduction of the new concept, pre-charge bail, it was of the view that its wide operation could not stand up to constitutional scrutiny in a free and democratic society. The association expressed the view that the new regime would have an impact on the constitutional rights of citizens, including their right to liberty, privacy, and freedom of movement. Chairman said that it was her understanding that the association was submitting that the concept of pre-charge bail should be restricted to cases where there were reasonable grounds. She added that there was a contention that the word defendant should not be used as an umbrella term for all individuals who are arrested or detained on reasonable suspicion of having committed an offense. She recalled the view previously expressed by some individuals that the term was traditionally used in reference to a person formally accused of an offense. She asked Ms. Grant to comment on the matter. Ms. Grant responded that the word defendant was considered to be a suitable umbrella term because although an individual was presumed innocent until proven guilty, that person, once suspected of having committed an offense, was involved in criminal proceedings which involved various stages. The chairman pointed out that there were several terms used within the criminal justice system to describe people at various stages. She remarked that an individual who was reasonably suspected of having committed an offense was generally regarded as a suspect. And if the person were to be formally charged, the term accused was used. She said that if that individual were to be convicted, he or she would be referred to as a convict. She recalled that some presenters had expressed the view that an individual who had not been charged should be treated differently from someone who was charged. She asked Mr. Foreman to comment on the matter. Mr. Foreman said that it was his understanding that the presenters would have preferred a term other than the term defendant. From a legal perspective, he said he did not have any concerns because the term was clearly defined in the bill and therefore it was clear as to the context in which it could be used. It was noted that there were no legal or constitutional issue with the use of the term. However, the committee could consider how to strike a balance between the perspective of the drafter and the concerns raised. The chairman recalled that Senator Campbell Rodriguez had expressed strong concerns about the use of the term defendant. Senator Campbell Rodriguez said that Mr. Foreman had indicated that there was no issue with legality and therefore effort should be made to communicate with people for them to have a clearer understanding regarding how the term would be used. The chairman said she understood how people felt about the use of the word and added that there would be public education. She stated that the committee could agree to retain the use of the word given that there were no issues with legality. She reminded the committee that there was a constitutional threshold that one would have to meet to ensure that the deprivation of liberty was not arbitrary. She pointed out that there had to be reasonable suspicion that the person to be deprived of his or her liberty had committed an offense. Kamele Golding. Ms. Wilkinson read Ms. Golding's submission verbatim. Ms. Golding indicated that Clause 5.3 posed constitutional issues because an accused could be held in custody for 120 hours awaiting an identification parade. It was therefore proposed that the 48-hour time period specified in Section 5.1 of the current Act be retained. The chairman stated that effort was made to ensure that the approach was constitutional and lawful. She pointed out that there were certain important administrative steps which had to be taken in holding an identification parade, and it was necessary to educate the public in order for people to understand that because a time frame was given, it did not mean that something could not occur before that time. She said that if public officials were committed to serving the public more efficiently and effectively, then actions could be taken as quickly as possible without compromising the process. Jamaica Constabulary Force, JCF, Identification Parade. Ms. Wilkins noted that the JCF had proposed that Clause 5, subsection 3 be amended to provide for the matter to be referred to a judge in chambers within a 120, I think hours is missing there, hours of an individual's arrest or detention. Reference was made to Section 22 of the current Act, which made provision for an identification parade to be done in the absence of an individual. The JCF recommended that Section 22 be incorporated into Clause 5, subsection 3 of the bill because the incorporation of that section would preserve the anonymity of suspects in circumstances where the identification parade could not be held within the timeline stipulated and in doing so would remove the possible concerns of the defense counsel. The JCF noted that the proposed amendment might result in the need for an amendment to Section 63, Big A, subsection 3 and 4 of the Judicature Parish Courts Act, which could be achieved through Clause 24 of the bill. In providing a rationale for their recommendation, the JCF submitted that Clause 51, subsection 1A, allowed for the question of bail to be considered within 24 hours where a defendant had been arrested or detained but had not yet been charged. It was pointed out that Clause 5, subsection 3, required a defendant to be brought before a judge within 120 hours where an identification parade was required. But if the identification parade was not held within that time, the requirement to be brought before a judge still remained, and the identity of the defendant could be known prior to an identification parade, thereby affecting the integrity of the identification parade. The chairman said the concern expressed by the presenters was that there was a possibility that a defendant could be exposed. It was, therefore, being recommended that the bill be amended to ensure that there would be no likelihood of that occurring because it could prejudice the case. Ms. Wilkins read Section 22 of the current Act, which indicated that, I think open quote, a person who had been arrested or detained should not be brought before it should substitute resident magistrate for parish court judge or a justice of the peace, but the matter shall be referred to a substitute with parish court judge or a justice of the peace who shall make any such order in the absence of that person, full stop, close quote. She pointed out that the provision was not in the current bill. The chairman asked Ms. Grant to comment on the matter. Ms. Grant referred to Clause 5, Subclause 3, and pointed out that it provided for a longer time for a person to be brought before a judge. She queried whether the intent was for the identification parade to occur prior to being brought before the judge. She added that provision was being made for the person to be brought before the judge instead of the order being made in his or her absence, because a longer time was being given, presumably to allow the identification parade to take place before the person was brought.
Madam Chair?
Yes.
Just a slight correction to what is depicted as a verbatim reading of Section 22 of the existing Act, where it says, Ms. Wilkins read Section 22 of the current Act, which indicated that a person who had been arrested or detained should not be brought before a resident magistrate or justice of the peace, but the matter shall be referred to a resident magistrate or justice of the peace who shall make any such order in the absence of that person. The wording is a little incorrect. It's not that the justice of the peace who shall make any such order in the absence of that person. Sorry. All right, no, sorry. I stand corrected. It's okay.
All right. The chairman queried what would occur in a case where a defendant was not brought before an identification parade within the specified time. Ms. Wilkins responded that the current law did not require that person to be brought before the judge. However, it made provision for the question of bail to be considered. The chairman asked Ms. Grant to comment on the matter. Ms. Grant said that Clause 5, Subclause 3 could be amended to make it clear that the identification parade should take place before the person was brought before the judge. She later questioned whether it would be better to revert to the current provision in the Act. Chairman subsequently asked Mr. Foreman for his opinion on the matter. Mr. Foreman said there was a requirement to bring the person before a judicial officer as soon as possible and pointed out that if there was a need for more than 120 hours due to the complexity of the case, a judicial decision could be made. Senator Campbell questioned whether any harm would be done in retaining Section 22 of the current Act. Chairman said that The concerns raised by the stakeholders were reasonable. She stated that that consideration could be given to increasing the time within which an identification parade could be held to allow for complex cases. However, there should be no improper exposure of a person under any circumstances. In order to provide a remedy, Ms. Grant suggested that subsection 3 could be retained. However, a second tier could be added. She proposed the following. Where an identification parade is required in relation to a defendant, A, the defendant shall, instead of the time specified in subsection 1, be brought before the judge within 120 hours after the arrest or detention. And in any case where the identification parade is not held within the time specified in paragraph A, the matter shall be referred to the judge, who shall determine the question of bail in absence of the defendant. May I ask Ms. Grant to reconsider this, but I'll come back to it as a matter arising. Something just jumped out at me.
No, I think this wasn't the provision that was settled on. There was further discussion that was returned.
Yes, all right, good. Ms. Wilkins pointed out that the amendment proposed by Ms. Grant would not resolve the issue. She further pointed out that the JFC was recommending that the existing provisions be retained to ensure that a suspect would not be brought before the judge. She said that at present, the law did not include a specific time within which the identification parade should occur. It only stipulated that the matter should be brought before a judge in the absence of the person suspected of committing an offense. She said that if the first limb remained, it would not have resolved the issue identified by the JCF. Ms. Grant responded that the second limb would address the case where the identification parade was not held. The chairman said that the time was being expanded to ensure that an identification parade would be held. Member Williams said that at present, if the police required more time to conduct an identification parade, especially on a habeas corpus application, they usually attended on the court and would indicate to the judge.
That would be attend on the court, not attended on the court. We usually attend on the court.
Right. They usually attend on the court. But in the reported speech, is it grammatically incorrect that they usually, I guess you don't say you usually went somewhere, you usually go somewhere, that they normally attended. I'm just thinking out loud. All right, we'll correct it for grammar. All right. And would indicate to the judge that they needed additional time, and the judge would inquire into the matter and exercise his or her discretion and make a determination as to whether or not to grant the police time required for the identification parade. He pointed out that where an inordinate amount of time had passed and there was no proper explanation and the identification parade did not materialize, the judge would make a decision as to whether the person should be charged or released. He advised that if a person was not identified, the matter would be concluded, but if he or she was identified, not really if they were, then charges would be laid and the question of bail would arise. He advised that at present, no person who was held for an identification parade would be brought before the courts. The chairman made reference to Clause 5, Subclause 3, and pointed out that the concern was that there was a high possibility that an identification parade might not be held, but there would still be a requirement to get an order of the court. She said that the interest of justice would not be served by exposing a person who was suspected of committing an offense and taking him or her in person before the court. She added that that was a gap which needed to be addressed. Chairman inquired about the timeline within which identification parades should be done at present. That doesn't read grammatically correct. The timelines within which identification parades were done. What should be done? Ms. Wilkins indicated that there was none. Chairman advised that the policy was to specify a reasonable time frame, and it was decided that 120 hours would be allowed for holding an identification parade. Secondly, as part of the policy, provision should be made for a judge to extend the time if necessary. However, one would not want the suspect to be exposed. Ms. Grant was asked to consider how the provision could be reworded to reflect the policy. Ms. Grant suggested the following. 3, where A, more time than the time specified in subsection 1, subsection 1A is required for an identification parade to be held in relation to a defendant, the defendant shall, instead of the time specified in subsection 1, be brought before the judge within 120 hours after the arrest or detention. Or B, where an identification parade is required to be held in relation to a defendant but has not been held within the time frame specified in paragraph A, the matter shall be referred to the judge, who shall either 1, specify such further time and shall allow for the holding of the identification parade upon the expiration of which a defendant shall be brought before the judge, or 2, determine the question of bail in the absence of the defendant. Member Williams inquired about the time frame for the consideration of the bail. The chairman said that the issue to be resolved not only pertained to the expiration of time within which the defendant would be brought. She commented that there were 2 matters to be addressed. One related to the court being able to make an order, including the consideration of bail, and the other to extending the time within which to hold an identification parade afterwards without prejudicing the case. Ms. Grant responded that that would be achieved from what had been proposed. She questioned whether the committee wanted to revert to the proviso and forget the time provided for. Ms. Wilkins expressed concern about the proposed wording of Clause 5.3b. She said that Section 22 was not tied to bail. She further said that based on the provisions under that section, a person who was arrested or detained must be brought before the court within 24 hours. She added that if an identification parade were to be held, that person would not have to be physically brought before the court. However, the court must make an order if think fit in the circumstance. That should be it thinks fit, not if. She commented that the court was not constrained in any way that it must consider bail or an identification parade. In fact, it would use its discretion to consider the circumstances which had been present and make the appropriate orders. The chairman commented that consideration had been given to what should be done with someone who was lawfully arrested or detained but had not yet been charged. After carefully considering the matter, Ms. Grant questioned whether the intent of the policy was for the new subsection 3b2 to state that instead of requiring the judge to determine the question of bail in the absence of the defendant, he or she should make such order as he or she thinks fit in the circumstances in the absence of the defendant. The chairman answered in the affirmative. Ms. Wilkins, you want to help me with the reading? We're almost through. Oh, we have some pages to go.
Jamaica Bar Association. Ms. Wilkins said that the association has made recommendations in relation to clause 5, 1A, B, and C. Should there be a comma between A and B? 5, 1A, comma, B, and C.
Yes.
It was proposed that clause 5, 1A be amended to place a clearer and more definitive duty on the justice of the peace and the police, who must decide the question of bail within the prescribed time and not just consider the question of bail. Ms. Wilkins said that it was her understanding that there were issues with the use of the word consider. Ms. Grant explained that based on the provision in paragraph B, a decision will be taken after considering a matter to either grant or refuse bail. After deliberating on the matter, the committee decided that it would not accept the recommendations that clause 5.1a should be amended. Ms. Wilkins noted that the association also recommended that the period for bail to be decided by the police or a justice of the peace should return to 24 hours. The chairman acknowledged that there was a lack of timeliness in taking action within the system in some instances. However, certain steps had to be taken before decisions could be made, and so the issue of reasonableness had to be taken into account. She pointed out that in some instances, 24 hours would be impractical. He later made the point that 48 hours was the maximum period being allotted, which meant that, if possible, a decision would be taken sooner. Is it would be taken sooner or could? I think it should be a decision could be taken sooner.
Well, yeah, could.
Change would to could.
It could. You can say that the association had proposed that clause 5.1b be amended so that there was a presumption in favor of the constitutional right to bail, unless, in the opinion of the assigning official, one of the reasons for the assigning official, is the assigning official correct, Ms. Grant? In the opinion of the assigning official?
Oh, deciding.
It should be deciding.
Oh.
Deciding official.
Yes. In the opinion of the deciding official, one of the reasons for denying bail sufficiently outweighed the constitutional right. The association submitted that it was worth noting that clause 6.1 spoke positively to a defendant charged with a criminal offense being entitled to bail unless there was sufficient cause for holding the defendant in custody. It was highlighted that a suspect's right to bail before charge should not be expressed in any lesser manner than a defendant who was subject to a charge. The association proposed that the provision be reworded as follows. After considering the matter specified in subsection 6A, B, C, D, E, or G, and considering the available conditions in subsection 9, the deciding official shall grant bail to the suspect unless, in their opinion, any of the matters so specified justifies the denial of bail and there are no conditions that could reasonably protect against concerns identified by the deciding official. Ms. Wilkins stated that the Norman Manley Law School had also submitted that whereas there was an express statement of entitlement for the person who was charged, that was not the case for the person who had not been charged but was detained. Mr. Foreman said that he wanted to review the issue of time. He pointed out that in the case of a person who had been charged, the maximum time given for a decision to be taken regarding the grant of bail was 48 hours following that person's detention. However, in the case of one who had not yet been charged, the time period in which the person was required to be brought before the judge exceeded 48 hours. He said that the time period was more than 48 hours because the justice of the peace or a higher ranking officer had the discretion of granting bail within 48 hours, and then another period of time would elapse before the obligation to be brought before a judge. He said that it would be anomalous for a pre-charged person to wait for 72 hours before being brought before a judicial officer, whereas the person who was charged would only wait for 48 hours. He suggested that the committee reconsider this issue. The chairman responded that it was expected that when an individual was charged, the process would be quicker because there was evidence that the offense was committed by that person. In the case of the pre-charged person, time was needed to gather information in order for a decision to be taken. He pointed out that greater latitude will be given depending on the stage of the criminal proceeding. Greater latitude will be given depending on the stage of the criminal proceeding. She said that she was aware that there were some who felt that individuals who had not yet been charged should be treated more favorably, but various factors had to be taken into account. Mr. Foreman responded that the intent was to prevent, minimize, and eliminate arbitrariness where a judicial decision was to be made. He pointed out that the state, having satisfied itself that there was reasonable suspicion that an offense had been committed, would then have to decide how soon an individual should be brought before the court if he or she had not been released conditionally or unconditionally. He questioned how one would assess reasonableness. He further questioned why a person who had not been charged should wait a longer period of time when one who had been charged than one who had been charged to be brought before the court. In elaborating the point, Mr. Foreman made reference to Clause 51A, which dealt with people who had not yet been charged. He later referred to Clause 51C and said that there were 2 48-hour periods that would apply to such a person. Ms. Grant clarified that 2 48-hour periods would not pass without the issue of bail being considered. She indicated that in the first instance, there was consideration and the determination would be made. He made reference to 51C and pointed out that there would be a reconsideration of the issue after 48 hours. After the 48-hour period had elapsed, something is needed between after and 48. I figure after.
Yes, I think the would be appropriate.
Okay. After the 48-hour period had elapsed, the chairman asked Mr. Foreman how he arrived at the conclusion that there would be 2 48-hour periods. She explained that the question of bail outside of court, station bail in brackets, would first be considered. She said that if a question was taken that station bail would not be granted, the individual would be brought before the court and would be either released or further remanded. Mr. Foreman questioned whether station bail could be considered in the context of a person who had committed one of the prescribed offenses. It should be offenses, not offices. He later referred.
You said that. Sorry, what was the correction, Ms. Wilkins?
Instead of offices, at the end of the first sentence, it should be offenses.
Right.
Okay. He later referred to Clause 6 of the bill, in brackets, grant of bail after charge but prior to conviction. Chairman said that consideration should be given to Part 1, in brackets, offenses in respect of which bail may only be granted by a judge, and Part 2, in brackets, offenses for which the application for bail shall not be made after conviction.
Excuse me. Is that a would or a should?
Member Rodriguez?
Yes, is that a would or a should in the sentence prior? No, I can't find it. The chairman said that
consideration should be given.
So it's, in the minutes it's would, right? Am I thinking correctly? We need to change that would to should.
So we read, the chairman said that consideration should be given to Part 1. That's how that would be.
Because you also read it as should, and that made sense to me, but the would there is incorrect.
All right. Okay, moving on. She further said that adjustments might have to be made to the provision in light of the concern raised. She read clause 6 as follows. 6.1. A defendant who is charged with an offense that is punishable with imprisonment, A, is entitled to be granted bail by the deciding official unless the deciding official is satisfied that there is sufficient cause for holding the defendant in custody, and B, shall not be held in custody for longer than a period of 48 hours without the question of bail being considered by a deciding official who is neither the arresting officer nor an officer involved in the investigation of the offense. Mr. Foreman read reference to section 6.3. It should be clause 6.3, not section 6.3. Mr. Foreman made reference to clause 6.3, which read as follows. In the case of a defendant who is charged with an offense listed in part 1 of the second schedule, the question of bail may only be considered by the judge, not a judge.
Yes, in the clause it says a judge, not the judge.
Right, so it's a judge. He pointed out that the pre-charge regime, that under the pre-charge regime, bail could be considered out of court for a person who was suspected of committing a crime. However, bail for a person who had been charged with certain offenses could only be considered by a judge. Yet reiterated that the person who had been charged could not be kept longer than 48 hours without the consideration of bail being given, and it was a judge who would decide whether bail should be granted. The chairman said that she understood the point that Mr. Ford was making. Take a break for lunch at 1:26 p.m. She indicated, who is she? The chairman. And please change the sheet to the chairman. The chairman indicated that the members could consider the provision during lunch. The meeting resumed at 2:05 p.m. Ms. Grant agreed that the limitation about the consideration by a judge only applied in the case of people who had been charged. The chairman said that the committee would continue the deliberations on clause 5. Hold on. The sequencing of the chairman said the committee would continue the deliberations of clause 5 would suggest to me that it should have come prior to Ms. Grant agreed that the limitation about consideration by a judge only applied in the case of people who had been charged.
Yes.
Yeah, I think that sentence should precede. The chairman, that sentence should precede the sentence starting with this one. And then that makes me want to. Okay, so it will be the chairman pointed out that many of the presenters had raised concerns. Yeah? Had raised concerns.
Concerns with an S.
Yes. About the constitutionality of the pre-charge regime, and added that some did not appreciate her boldness and confidence in the constitutionality of the regime. She commented that it would have been highly irresponsible to have come to Parliament with a regime that could not withstand scrutiny, and added that the issue was considered at length and after much research. Chairman indicated that the various submissions have been considered and some would be useful in making the bill more readable, understandable, and better able to achieve the policy goals. She commented that she had a discussion with the technical team during the break regarding whether it may be useful to provide for the treatment of a defendant who was arrested or detained on reasonable suspicion of having committed an offense and set a general standard of treatment, and also rearrange the bill to address the concerns raised in the meeting regarding the identification period and the timeline within which one should be brought before the courts. Ms. Grant questioned whether the proposed redrafting would be based on the change in the approach. Hold on. Ms. Grant questioned whether the proposed redrafting would be based on the change in the approach which would be taken. I'm not sure that sentence is very clear. I don't know, Ms. Grant can assist with, but that sentence just doesn't seem very clear. Would be based on the change in the approach which will be taken.
Be a change in the approach that is being, yes, it's not reading correctly to me, but I think the query is whether, what I was querying is whether we should do a little rearranging of the bill to address the concerns raised. And I think the query was about redrafting it. Maybe Ms. Grant can remind.
I'm wondering if B was if it was based on a change in the approach which is to be taken or something. The approach to be taken.
Yes.
A change in the approach to be taken.
Yes.
I think it would clear it.
Okay.
The chairman answered in the affirmative. The chairman asked Ms. Grant about her understanding of the amendment which was proposed during the brief. Grant responded that the committee had discussed how to streamline the treatment of a pre-charge and charge regime, of the pre-charge and charge regime, to ensure that there would be no
pre-charge and post-charge.
Yes.
Yeah, I think the reference there should not be to the committee, but the technical team, because that's who the discussion was had with, not the committee.
Where it says
yes, a committee. Yes, right. It's a technical team.
Okay. So it will be read then. Ms. Grant responded that the technical team had discussed how to streamline the treatment of the pre-charge and post-charge regime to ensure that there would be no inequalities with how both were treated.
No, it was the committee, Ms. Grant. That discussion had taken place in the committee about streamlining the treatment of the pre-charge and post-charge regime. So I think what is stated there is correct. You were merely referencing that discussion had taken place.
Oh,
yes.
Okay. So the only change would be to add post before charge in the second line of that sentence.
Sorry, I'm not.
Pre-charge and post-charge, so you got to add post.
But that's what's there.
No, post isn't there. It says pre-charge and charge.
Where?
The second line of the sentence.
You're reading something different from what I have. Ms. Grant responded
that the committee had discussed how to streamline the treatment of the pre-charge and charge regime and
post-charge.
Minus post-charge.
And post-charge regimes.
Mm-hmm. So post needs to be inserted.
No, post is in it. Post is in the version that I have before me.
It's not in the one. It's not in the one I have.
Or 2 cents. It's also in my.
Is it in your copy? Do you have post-charge?
Yes, I have it in mine.
I have it in mine.
All right, that's not much to detain us.
Okay. Inquired about the decision taken by the committee in relation to the reference to Part 1 or Part 2 in the second schedule in Clause 5.1. She further inquired whether the provision in Clause 5 would relate regardless of the offense. The provision in Clause 5? That's a bit obscure. I don't, Ms. Grant, would you recall?
Clause 5.1 clearly refers to part 1 or part 2, so the query was whether that should remain.
5.1 then is what we, not the entire clause 5. Is the provision in clause 5.1?
But that's what I have, that's what it says in clause 5.1.
Oh, thank you. What happened here?
Yes, sorry. It should say clause 5.1. Agreed.
Oh, you have me worried again that there's a difference between what I have. So the one should be one. The subclause 1 needs to be put in. So she further inquired whether the provision in clause 5.1 would relate regardless of the offense. So that changed, that correction, you see. Mr. Foreman said that the policy intent was that the pre-charge regime would be limited to the offenses listed in part 1 of the second schedule.
Ms. Wilkins?
Yes, Minister. Yes, Minister. Oh, it says in here too? No, I think ours.
It seems we're having an audio challenge.
Oh.
I was saying that my version of the minutes has clause 5, subclause 1.
Here. Not sure what's happening here. That's the second one now. Oh, wow. So maybe, all right, we'll just put it in on our copy then. Okay, so I continue reading?
Yes.
Ms. Grant questioned whether the stipulation that a matter could only be heard by a judge was being removed. The chairman clarified that if a person was suspected of having committed one of the offenses listed, then he or she should be treated in a particular way. But if he or she was charged with committing one of the offenses, then bail could only be considered by a judge. Hold on a minute. The chairman clarified that if a person was suspected of having committed one of the offenses listed, then he or she would be treated in a particular way. But if he or she was charged with committing one of the offenses, then bail could only be considered by a judge.
It's not inconsistent.
I realize one is in a case of suspected and the other one is charged. Yes. She added that the provision had to be tidied up for clarity. She then said that the aim was not to exclude members from the discussion, but the consultation with the technical team was necessary because they had a critical role to play. Closing remarks. The chairman said that the committee would take a 2-week break for the records of the committee's meeting to be prepared and for a report on the deliberations to be drafted. And the date of the next meeting was set for Thursday, April 13 and 20. And their adjournment was taken. There will be no other business. On a motion by Senator Campbell Rodriguez and seconded by Member Williams.
Madam Chair. Madam
Yes,
Chair.
Member Campbell Rodriguez.
On the closing remarks, where it says we were on a 2-week break for the records of the committee meetings to be prepared and for a report on the deliberations to be drafted. I probably misunderstood, but I thought it was also for the provision to be tidied up for what you suggested, where we bring certain sections together that were now apart, etc. That whole discussion in the paragraph preceding that. I thought that was the main reason we were breaking, to give Ms. Grant and her team that time to work through. reworking how those provisions are written. I could be wrong.
It wasn't the report. That's an error. It's a clear error.
Oh.
It would be for the redrafting to be done.
Yes. Could we make that correction that it wasn't for a report?
Right. We have had corrections along the way, and for those who were not present, they would have been brought up to scratch. Can we move for the minutes to be confirmed as corrected?
So moved, Madam Chair.
Seconded.
Confirmed by?
Campbell Rodriguez.
And seconded by?
Member Charles.
All right. Any matter arising? The real matter arising is a redrafting that has taken place and is to be circulated. I am thinking that, let me see what else. So, just going to the new business, consideration of outstanding matters arising we have dealt with. Before I move from this last minute.
Madam Chair.
Yes.
We were sent a document titled Report of the Joint Select Committee, but I'm wondering if that report is a bit premature. I mean, I just got it today, so I haven't had a chance to look at it. But isn't it premature given that there will be redrafting of certain sections?
That's an error, Member Campbell Rodriguez. It was a redrafting. It's an error there because the report comes at the end of the deliberation.
Right.
Yes.
Okay.
So that's an error. All right.
Thank you.
So just to say that the meeting that was scheduled for April 13, it's April 20. Which of these meetings we didn't have?
April 13.
And today's April 20, right. The meeting of April 13 was cancelled based on the report from the committee clerk that more time was needed to have these outstanding minutes ready. She requested an additional week, and I'm very pleased that she used the additional week, and we are now up to date with all the minutes. I know the clerks are under pressure for the record. And while it is a duty of the clerk to produce the records, I still want to say thank you, Madam Clerk, because I know the workload is heavy. We have numerous joint select committees meeting, and they're meeting in rapid succession, and the workload is heavy. And we need more clerks to lighten the load and to get the work turned around quicker. All right. The CPC also utilized the time well, and we have a revised bill based on all that we had discussed. It is, we took the decision that, on the advice of the CPC, that it would be tidier to propose a revised bill. And it is ready for this dissemination. So, Just a minute. The review of the draft report would be I crave your indulgence. Okay, so the review of the draft report is not review. It should be corrected for review of the revised draft. So there's a correction to the minutes at item 7 under new business. So the first is consideration of outstanding matters, and those were considered with all the minutes now in and confirmed. And instead of review of draft report, it would be review of revised draft bill. Or review of the revised bill. Revised draft, yes, of the bill. All right. The revised draft will be circulated today for members to get some time to look at against the deliberations of the committee based on the presentations made. The clerk is going to send the revised draft. No? And I know that members will need some time to look and check. And that really, I think, would be a good use of today's time, given the hour, that we would have brought the work of the committee up to date. And the further deliberation would be of the revisions that have come after deliberations. Members, what say ye?
Agreed, Madam Chair.
Yes. All right. And I recall Member Paulwell. Member Paulwell and the opposition team, Member Fitzjackson, please utilize the time to consider what it is that you need to consider, because we have to move now to finalize the review of the bill.
Yeah, well, we must say that in this regard, you have been very patient, and we really appreciate that.
Madam Chair, my colleague preempted me.
Come on camera, Member Jackson. Why are you hiding?
my colleague has preempted me in making that observation and that commendation. Notwithstanding, I would allow not adding my voice of endorsement to what he has said.
Are you endorsing?
How accommodating you have been in
this regard.
In this regard, regarding our submission and the Yes. I got a clear sense, Madam Chair, that you sought to be very inclusive of the opinions, though not necessarily inclusive of the conclusion. But we do appreciate that. We do appreciate that in all sincerity.
We are serving the people. And indeed, I think, there are so many lessons to learn from this exercise and other things. So many. I think I will collate them at some point before we conclude the deliberations. I'm advised by the clerk that the revised bill has been sent to all members of the committee. So you may check your inbox. We have some printed copies here in the chamber.
I will ask, Madam Chair, that if the Parliament could just make a hard copy available for collection.
All right.
Shortly hereafter.
We do have some here in the chambers, but only two members are, plus, in addition to me, are here in the chambers. So the clerk
I will make collection tomorrow.
Yes. All right. So is there any other business that any member or any member of the committee or member of the technical team wish to have addressed? If there is no other business, then...
Madam Chair, did we agree on the next meeting?
Yes, we are looking at April 26 at 10:30 a.m. That's Tuesday, the 26th. And then on May 9 at 10 a.m. So date and time of next meeting, April 26, 2023 at 10:30 a.m. And then on May 9, we're really competing for space here because other matters are scheduled in the chamber. May 9 and May 26. Maybe just I crave everyone's indulgence. All right, just checking availability. We're setting 3 days, April 26, 10:30 a.m., May 9, 10 a.m., and May 11 at 2 p.m.
They repeat those again, Chair.
April 26, 10:30 a.m., May 9, 10 a.m., May 11, 2 p.m.
Madam Chair, challenges with the 3 dates as contained in my diary.
Okay.
But so if those are the dates that you are constrained to go with, well, at least closer to the time, I probably can see if I can, or as we go along, I can see if I can make any adjustments to any of them. I possibly can do with the 26, make an adjustment in what I see here. But
all right.
The night.
Noted. Noted.
And we have the challenge with the 9th and the 11th.
All right, we'll see how that goes. But may I ask members to use the time between now and the next meeting to go through the bill? We have to bring these meetings to an end soonest. If there is no other business, we can move for the adjournment of the meeting.
So moved, Madam Chair.
Thank you. Meeting adjourned at 4:25. So that's Rodriguez, Campbell Rodriguez, and Paul Will. This meeting of the Joint Select Committee on the bail bill is adjourned.